My name is Bob Simmons, and I am a partner at the Wilmington, Delaware law firm of Potter, Anderson, and Caroon. I'm also a senior legal advisor to CSC Publishing. Joining me today are my Potter Anderson colleagues, Mike Whitaker and Mike, for the later discussions. We're going to talk about corporate activities that generally do not require qualification. We'll also cover some that do require qualification. We're going to talk a little bit about the intersection between qualification and internet and e-commerce operations. We'll also talk about, as a practical matter, what corporations have to do to qualify, what can they do to cure a situation where they were supposed to qualify but didn't, and finally how they terminate a successful qualification when it's no longer needed. We will touch on some of the consequences of failing to qualify, and we will also mention some other regulations to keep in mind beyond qualification when you have a company that's going to be doing business outside its state of formation. And at the end, if there's time, we will take some questions. One thing to keep in mind today is that we are Delaware attorneys, and our experience generally involves Delaware law. We will use examples from Delaware law to illustrate concepts that apply in other jurisdictions. But bear in mind, each state will have its own rules when it comes to foreign qualification. So it's always important to first check the relevant statutes in any given state. And those are conveniently described in the CSC Qualification Handbook. With that said, let's get started. Mike Whitaker, why is qualifying to do business in a foreign jurisdiction something that attorneys, paralegals, other decision makers need to be aware of?
Thanks, Bob. As most of us know, a company, whether it be a corporation, an LLC, or a partnership, is a separate legal entity that is generally created under the laws of just one particular state. The company exists because the laws of its state of formation allow it to be formed and to conduct business in that state. As long as the company is properly formed and only conducts business in its state of formation, the company will most likely not be subject to regulation by other states. However, in today's economy, companies do not usually limit their operations to their state of formation. And before a company conducts any business in a foreign state, meaning a state other than its state of formation, it should first determine whether its proposed business activities in the foreign state will require the company to qualify under the foreign state's qualification laws. These qualification statutes stem from each state's desire to subject companies conducting business within its borders to the jurisdiction of that state's court system so that its courts can render valid judgments against the company in the event a lawsuit is filed against the company in that state. To demonstrate the importance of understanding the impact of qualifying to do business in a foreign state, we wanted to start today's discussion by highlighting a recent case from the Delaware Supreme Court decided just 3 or 4 weeks ago. However, before jumping into that case, we need to briefly explain the concept of personal jurisdiction, as it plays a central role in the case and can be affected by qualifying in a foreign state. Personal jurisdiction is a legal concept that refers to the power of a court to render an enforceable decision against the parties to a lawsuit. There are 2 types of personal jurisdiction. If a court has general jurisdiction over a party, that means the court can render a decision against that party relating to any issue, regardless of whether the lawsuit is related to the party's contacts with that particular state. On the other hand, if a court only has specific jurisdiction over a party, the court may only decide a lawsuit that arises out of or relates to the party's specific contacts with that state. So with that in mind, Mike Maxwell will now give us a short summary of this recent Delaware case.
Thanks, Mike. Genuine Parts Company v. CPEC is a 2016 Delaware Supreme Court decision that interpreted the scope of Delaware's registration statutes for non-Delaware companies doing business in Delaware. In this case, the court ruled that such statutes provide a means for service of process, but do not confer general personal jurisdiction over a non-Delaware company. Relying on prior U.S. Supreme Court decisions, the Delaware Supreme Court reversed a lower Delaware court decision that held that a Georgia company consented to general personal jurisdiction in Delaware merely by registering to do business in Delaware as a foreign company. In the lower court action, plaintiffs Ralph and Sandra CPEC, residents of Georgia, sued Genuine Parts Company for allegedly exposing Mr. Cepek to asbestos during his employment with Genuine Parts. Genuine Parts registered to do business in Delaware and designated an agent for service of process in Delaware under Delaware's foreign company qualification laws. Genuine Parts activities in Delaware were minimal and had no connection to the Cepek's claims. Relying on prior Delaware precedent, the lower court denied a motion by Genuine Parts to dismiss the case for lack of personal jurisdiction, concluding that Genuine Parts had consented to general personal jurisdiction in Delaware by complying with Delaware's foreign company qualification statute. On appeal, the Delaware Supreme Court explained that the broad interpretation of the Delaware qualification statute adopted in prior Delaware cases now conflicted with the U.S. Supreme Court's decision in Daimler, and a proper reading of the Delaware statute would permit service of process to be made upon a foreign company, but would not constitute consent to a general personal jurisdiction. I'll note here that U.S. Supreme Court decisions referenced in the Genuine Parts case shook up established law on personal jurisdiction in the United States. In the Daimler decision, the court held that personal jurisdiction can be established if a foreign company has a principal place of business within the state where the suit is brought, or if the foreign company is incorporated in that state. However, if neither of those elements is present, then in order to find personal jurisdiction, courts must determine whether that company's affiliations with the state are so continuous and systematic as to render it essentially at home in that state. In other words, the contacts must establish the same type of close relationship with the state where the suit is filed as being incorporated there or owning a principal place of business in that state. Now, states have reacted to this decision in different ways. For example, Delaware has reacted in the judiciary by adopting the U.S. Supreme Court's interpretation, as evidenced by the Genuine Parts decision that we just discussed. Other states have sought legislative responses to override the Daimler decision. An example here is that there's legislation to this effect working its way through the New York State Senate.
Thanks, Mike. It sounds like the Genuine Parts case is a good example of why it is important to understand the consequences of qualifying to do business in a foreign jurisdiction, as well as the consequences of not qualifying. Also, folks need to keep in mind different states may respond differently to this precedent. So it is always important to review the relevant statutes in your particular jurisdiction as well as the relevant case law. Let's move to slide 4 now. Mike Whitaker, how does a company determine if it is doing business for purposes of these qualification statutes?
Thanks, Bob. As you noted earlier, the first thing a company should do is get a copy of CSC's handbook because it examines questions like this and offers examples to help legal professionals understand whether a particular company needs to qualify in a foreign state where it is doing business. Next, they should review the qualification statute in each applicable foreign state, which incidentally are also included in the CSC qualification handbook. We're going to provide some general advice on these statutes today, but that is not a substitute for reviewing the actual laws. With that said, many qualification statutes define doing business in the negative. And what we mean by that is when defining the term doing business, the statutes provide a list of activities that by themselves are insufficient to require a company to qualify in that jurisdiction. These listed activities are normally referred to as exceptions to doing business. For example, Delaware defines which activities do not constitute doing business in each of its business entity statutes. If a company engages in any activities in Delaware that are not included in Delaware's exceptions to doing business, then the company must qualify to do business in Delaware or risk penalties for failing to do so. The potential penalties for failing to qualify will be discussed later in the presentation, but depending on the state, they can include being barred from enforcing contracts or bringing a lawsuit in the state, possible monetary penalties, and in some states, individual director liability. We should note that if a company engages in activities in a particular foreign state that are considered exceptions to doing business, and as such does not have to qualify to do business in that state, that does not mean that the company is not subject to personal jurisdiction or taxation in the state. In other words, a company may be subject to personal jurisdiction or taxation in a state by performing activities that are by themselves insufficient to cause the company to need to qualify in that state. As such, it is always important to keep in mind that there are other contexts in which a company's transaction of business has consequences such as jurisdiction and taxation. Also, note that there may be exceptions to the qualification rules for particular types of businesses or industries. For example, in Delaware, there's an exception for out-of-state insurance companies. They are not required to qualify to do business in Delaware with the Secretary of State. However, they are subject to separate rules under other laws such as the state's insurance code. As such, it is important to keep in mind that regardless of whether a company is required to qualify to do business in a foreign state, there can be other licenses, permits, or regulatory issues that the company may need to comply with in order to do business in a particular state.
Please pardon the interruption. I'd like to announce the first CLE code for today's webinar. Attendees, please write this.
We are going to hear about corporate activities that typically do not require qualification, also known as exceptions to doing business. Some folks refer to them as safe harbors. Mike Maxwell, can you elaborate on these, please?
Sure. A company may be subject to sanctions and penalties if it transacts business in a state outside of its state of formation or incorporation if it doesn't first qualify to do business there. However, not all corporate activities require a company to seek qualification. The question of whether a company is doing business for qualification purposes is determined on a case-by-case and state-by-state basis. A widely accepted definition of doing business in a state, and as you'll note on the slide, is regular, repeated, and continuous business contacts of a local nature. But courts can, and often do, interpret and apply this definition differently. For that reason, a factual evaluation of the activities of the company has to be made. So I guess the first step requires identifying the relevant statutory provisions and exceptions in the applicable jurisdiction. This also requires one to understand whether there are different statutes to consider depending on the type of entity. For example, in Delaware, a foreign LLC is subject to a different qualification statute than a foreign corporation. Once a company has identified the governing statutes and exceptions, the next step is to review the relevant case law to understand how the courts have interpreted and applied the exceptions. The cases usually involve one of two factual scenarios. The most frequent scenario involves a plaintiff company trying to litigate in a foreign state in which it is not qualified to do business. In this scenario, the defendant typically attempts to prevent the suit by arguing that the plaintiff is barred from accessing the state's courts because the plaintiff's activities will constitute doing business there and the plaintiff is not qualified. The next most frequent scenario involves the non-qualified company as the defendant attempting to avoid being sued in the foreign state. The defendant usually argues that it cannot be sued in the foreign state because it was not doing business there. In both scenarios, the non-qualifying company attempts to demonstrate that its activities in the foreign state don't rise to the level of doing business in that state. A court resolving this issue generally analyzes the relevant statutory exceptions to determine whether a company's activities require qualification in that state.
Thanks, Mike. It sounds like sometimes a client would be well served to consult with experienced counsel and others who can help it navigate these scenarios. Let's turn to slide 7 now, so Mike Whitaker can spend a little time reviewing for us some of the exceptions to doing business that typically appear in state qualification statutes.
Thanks, Bob. There are a number of general exceptions that are common across state statutes. Again, keep in mind that we are discussing these today only in general terms, and you'll need to look into the individual state statutes for specific exceptions. With that said, the first exception deals with litigation. A typical provision would say that a company may maintain, defend, or settle any proceeding in the state without first qualifying to do business there. Thus, if a company's only activity in a particular state is to commence a lawsuit, then the company need not qualify to do business in that state. The next exception is that a company may hold board of directors meetings or carry on other certain internal corporate activities within a foreign state without having to qualify to do business there. Additionally, merely maintaining a bank account in a foreign state typically does not require qualification to do business. Mike Maxwell will now address a few additional exceptions.
Great, thanks. Another common exception is that a company may maintain offices or agencies for the transfer of the company's own stock and securities without having to qualify to do business. A company is also not transacting business for qualification purposes if it sells goods in a foreign state through independent contractors, but only so long as the sales transactions maintain interstate characteristics. Additionally, soliciting or obtaining orders through mail, employees, agents, or other channels in a given state will not trigger the qualification requirement, provided that the orders require acceptance outside that state, before they become contracts. The next exception on slide 7 typically is invoked by banks that create mortgages and then foreclose on the property secured by that mortgage. The states which have adopted these exceptions have agreed that creating mortgages and indebtedness and enforcing mortgages and security interest in property securing such indebtedness do not require the bank or company seeking to collect on the debt to qualify in the jurisdiction where the property is located. A somewhat related exception involves merely owning real or personal property in a foreign state. Although many states have adopted this exception, few state courts have interpreted it. This makes it difficult to draw general conclusions about the corporate activities that might fall under its protection. Mike Whitaker will address our last few exceptions now.
Thanks, Mike. Conducting an isolated transaction that is complete within 30 days and that is not one in the course of a repeated transactions of a like nature generally does not constitute doing business for qualification purposes either. It should be fairly simple to determine whether a company has complied with the statutory time limit in this exception, but it might be much more difficult to determine whether a company's activities constitute a so-called isolated transaction. The answer to that question can vary from state to state, and it will be important to analyze the case law of the particular state at issue to determine how that state's courts interpret the isolated transaction exemption. As a general matter, it is important to understand that a single act or transaction can be more than an isolated transaction if it indicates a willingness or an intent to conduct other business in the state. The key issue is whether the activity is sporadic and isolated such that it does not constitute carrying out the ordinary affairs of the company. The next general exception is for interstate commerce. The Commerce Clause of the United States Constitution prohibits states from regulating interstate commerce. States can only regulate intrastate commerce, meaning commerce within that state. Consequently, many states have adopted the exemption of transacting business in interstate commerce. Note, however, that the interstate commerce exception will apply even in those states that have not specifically codified it because the U.S. Constitution overrides state law. Therefore, if a company's activities within a state is merely incidental to interstate commerce, the company will not trigger the qualification requirement. However, if the activity becomes routinely localized in a particular state, the company will be required to qualify to do business there. The final exception we want to note is the exception for companies responding to state-declared emergencies. In 2014, the National Conference of State Legislatures adopted a Model Business Act called the Facilitating Business Rapid Response to State-Declared Disasters Act of 2014. Sorry, that's a mouthful. The idea behind the Model Act is to provide states with model legislation to waive qualification requirements for companies involved in the rapid response to state-declared emergencies, such as an earthquake, tornado, or even man-made disasters like chemical spills. Not all states have adopted this exception yet, so again, it is important to check the statute of the applicable state.
Thanks, Mike. Mr. Maxwell, are there any additional things to keep in mind regarding the general exceptions to doing business?
Yes, I think our listeners should always keep in mind that the exceptions we're talking about are generalizations. Each state statutes may have different exceptions from what we discussed here. For example, as we mentioned earlier, the Delaware General Corporation Law provides an exception to qualification where an insurance company is doing business in Delaware. Keep in mind that the type of entity you are dealing with will also often dictate which statute that a company will need to look to for the exceptions. For example, a foreign LLC engaging in activities in Delaware would look to the relevant provisions of the Delaware LLC Act, and an out-of-state limited partnership would look to the relevant provisions of the Delaware Limited Partnership Act. Let's move on now to slide 8.
Thanks, Mike. Now we come to activities conducted in a foreign state that are regular, systemic, extensive, and continuous, the kind that can trigger a qualification requirement. As you might imagine, this area of law is very fact-dependent. Many corporate acts fall into the gray area between those that obviously require qualification and those that do not. Here is where the CSE Qualification Handbook is very helpful, because it provides you with a list of activities that are likely to require qualification. While this list is not exhaustive, it is representative of the kinds of activities that typically require qualification. We'll turn to slide 9 now, and Mike Whitaker will touch on a few of the examples listed here.
Thanks, Bob. The first example is accounting. Many states have enacted licensing statutes that require out-of-state certified public accounting companies to obtain temporary permits before practicing in their states. Although the CSE book does not discuss these licensing requirements, accounting companies should note that they must obtain these temporary permits before conducting accounting activities in those states. Courts will often consider the state's licensing laws as one of several factors when determining whether a foreign accounting company is doing business in the state for qualification purposes. If we can now go to slide 10. Thank you. The next example has to do with banking. Most states have general qualification statutes that identify the maintenance of a bank account as a business activity that does not require qualification. In the 5 states that do not provide a bank account exception, the question becomes whether maintenance of a bank account triggers the obligation to qualify as a foreign company. For example, the Delaware qualification statute is silent as to whether maintenance of a bank account in Delaware requires qualification. At least one commentator has suggested, however, that the maintenance of a Delaware bank account alone or even together with other minor activities such as advertising in a Delaware newspaper would not by themselves be sufficient to constitute doing business in Delaware.
Thanks, Mike. The next topic we'll turn to involves the intersection of qualification to do business and Internet and e-commerce operations. Everyone knows that the Internet has revolutionized a company's ability to transact business across state boundaries. Whether buying and selling products and services or conducting virtual meetings or other business operations or just communicating, the sheer volume of activity that takes place over the Internet on any given day is mind-boggling. So it's no surprise that Internet activity has gotten lots of attention in the courtroom, and corporate decision makers are facing lots of legal issues involving their e-commerce and other Internet activities. A company's gateway to the Internet is its website. One significant legal issue regarding websites is whether a company's use of a website constitutes doing business in a state outside the one in which either the company is located or the website was created. So a company needs to determine whether maintaining or owning the website means that it has to qualify to do business in any state where either the website can be accessed or customers use the products or services offered on the site. Mr. Maxwell, does engaging in e-commerce and other Internet activities subject companies to foreign qualification statutes?
Thanks, Bob. There's not much in the way of statutory law and case law addressing the question of whether owning or operating a website constitutes doing business for qualification purposes. In a rare court opinion addressing the issue, the U.S. District Court for the District of Connecticut stated that solicitation of business through an Internet website fell within one of the enumerated exceptions to transacting business in Connecticut's qualification statute. The exception the court was referring to is the one which excludes solicitation or obtaining orders if the orders require acceptance outside this state before they become contracts. However, I'll note that numerous cases address a similar issue. That is, whether a company's Internet activities in a foreign state constitute doing business sufficient to justify the courts of that state exercising personal jurisdiction over the company. Exploring the issue of jurisdiction with regard to websites can be useful when trying to determine a company's need to qualify to do business based on its website activity. The important distinction here between transacting any business for purposes of personal jurisdiction and doing business for purposes of qualification statutes is that a greater amount of business activity generally is required in order to compel a foreign company to qualify to do business within a state than the amount of activity needed to merely subject it to service of process. This means, essentially, that it is easier for a company engaging in activities in a foreign state to satisfy the minimum contact test for jurisdictional purposes than it is to satisfy the doing business test for qualification purposes. Logically then, if a company's contacts with a foreign state are not sufficient to justify the exercise of personal jurisdiction, a court should find that those same contacts will not trigger a company's duty to qualify in that state. Mike Whitaker will now give us a little bit more detail on this point.
Thanks, Mike. As we touched upon in our discussion of the genuine parts case, the recent Supreme Court decision in Daimler has made a huge impact on judicial opinions regarding whether personal jurisdiction is created by Internet activity or websites. Although Daimler itself was not an Internet case, it explored the outer limits of personal jurisdiction in cases implicating global matters, including whether or not personal jurisdiction can be based on a website that can be accessed around the world. In that regard, since 2014, many other courts have used the Daimler decision to determine that personal jurisdiction cannot be based on the sole existence of an interactive website. For example, the Supreme Court of Utah recently determined that a foreign company selling audiovisual equipment in Utah could not be brought into Utah based exclusively on the company's publicly available website. Furthermore, the court held that making contracts in Utah and earning revenue there was not enough to satisfy Daimler's requirements of contacts that are so continuous and systematic as to render the defendant at home in Utah. Mike Maxwell will now discuss how recent cases have affected the analysis of when minimum contacts grant the court personal jurisdiction.
Thanks, Mike. Before the Daimler decision, many courts applied a sliding scale test tailored to Internet activities to determine the level or types of activities that constituted minimum contacts for general jurisdictional purposes. At one end of the scale were passive websites, which alone did not generate sufficient contacts with a foreign state necessary to establish personal jurisdiction. A passive website was one that was used to post information, did not actively solicit orders for goods or services, or support other commercial activities. Think of an informational site. At the other end of the scale are active websites. These are those websites that generate sufficient business over the Internet to establish personal jurisdiction. An active website serves as a gateway for conducting business over the Internet between the website owner and the residents of a particular state. Now, falling in between these two are interactive websites, the middle of the scale. And courts determined whether to exercise personal jurisdiction over an interactive website owner on a case-by-case basis. Interactive websites are hybrid sites that contain elements of both passive and active websites. These websites allow users to exchange information with the website creator, order products, make reservations, and conduct other business, usually with a credit card. The owner of an interactive website will not necessarily be subject to personal jurisdiction in a foreign state. To make this determination, most courts look at the level of interactivity and commercial nature of the exchange of information that occurs on the website, as well as whether the website owner targeted or aimed its efforts at the foreign state. Mike Whitaker is now going to discuss some of the additional facts that courts consider in evaluating jurisdictional issues for these websites.
Sure, Mike, thanks. Before the Daimler decision, specific personal jurisdiction could be established simply by passing what they called the so-called effects test. When using this test, a court would examine the intentional conduct of the applicable company to determine if it was targeted specifically at the state or its residents. Courts eventually reduced this effects test analysis into a three-part test. The test required a showing that the defendant first committed an intentional act which was expressly aimed at the forum state, and 3, caused harm, the brunt of which is suffered and which the defendant knows is likely to be suffered in the forum state. However, as a result of the Daimler decision, courts are now using the effects test, but only as one of the considerations in ascertaining whether contacts are continuous and systematic enough to render the foreign company essentially at home in the foreign state. Similarly, the status of the website, as described in the sliding scale test, meaning active, passive, or interactive, is still used by some courts, but it is only one factor of many in making a personal jurisdiction determination.
Thanks, Mike. Mike Maxwell, how does email, since it's so ubiquitous, How does that fall into the jurisdictional analysis?
Thanks, Bob. Well, there's minimal case law on the question of whether email sent to a party in another state can single-handedly establish jurisdiction. A few cases that have been decided on the subject, however, suggest that it can. In one Connecticut case, the court found that it had jurisdiction over a Massachusetts company in a resident's slip-and-fall action that occurred at the company's Massachusetts memorial, as the company engaged in conduct that included emailing and soliciting business by reaching out to Connecticut residents and seeking their membership in the memorial. However, this is still an evolving area of the law, so there's a lot to be determined in this area.
Who's going to give us a practical perspective on how companies qualify to do business in a foreign jurisdiction. Pat?
Thank you, Bob. Thank you very much. Yes, the first thing to consider during the qualification process is name availability. CSC will check the availability of a name in any state in connection with a filing that we're handling. If the name is not available, we will obtain information on the conflicting entity, the name, of course, the state, the name of the registered agent, and let you know whether the state will accept a consent to use a name. Not all states do this, but some states, if you can get the consent in writing from the party that already has the name, will let you qualify with that similar name. Another topic that we will discuss in very brief detail is the concept of qualifying under a fictitious name. If your name is not available, some states will allow you to add a modifying word to the name, sometimes with an additional form. It might need a resolution of the board of directors or an assumed name form, and they will let you qualify even though there's a very similarly named company there. Another aspect to consider is the notion of supporting documents. Most states require some proof of existence that your entity exists in the state of formation. So the great majority of states will require a good standing certificate. There are a few states that still require a certified copy of your certificate of formation or certificate of incorporation and your amendments. And then there are other states that don't require any supporting documents. Pennsylvania and Texas come to mind. Another thing almost every state requires is a registered agent. And my own state of New York is an exception to that. In New York, the Secretary of State is named the agent, and you just have to provide an address to which the Secretary of State can forward service of process. However, most of the other states, the agent has to be within that state, and the registered office obviously also has to be within that state. If you use CSC for your forms, we have a forms library, and on all our forms, our designation as agent is pre-printed on those forms. If for some reason, and we hope not, but if for some reason you want to appoint another agent, you can just change the agent on the form. So a lot of states now are requiring the registered agent to sign off as registered agent, which is a good thing, because a lot of times people will get forms and send them out for filing, and the registered agent doesn't know it unless they've heretofore been told of it or have accepted their appointment on the form. Other requirements that come into play in the qualification process are publication and recording. Not every state, but some examples are for corporations in Pennsylvania. You have to publish. You do not have to publish for limited liability companies. In my own state of New York, for both LLCs and limited partnerships, you have to publish. And it can be very expensive because in New York, it's triggered by the county you set forth in your application for authority, and you have to publish once a week for 6 consecutive weeks in 2 newspapers designated by the county clerk. So if it's my county here in New York, you're going to automatically get the New York Law Journal, and the expense can be as high as $3,000. So just something to consider when qualifying in New York. The most important thing, of course, though, is to prepare and file the required documents. In most cases, that's a simple form called an application for certificate of authority. So other states, they may have auxiliary forms that will also have to be filed. And then there's also, just like the forms are different in each state, the filing fees are different in each state. And they can vary greatly from the state of Hawaii, where it's a flat fee of $51, to the state of Illinois, where it's a pretty complex procedure. They take into consideration your business and property in that state versus your business and property everywhere, and that fraction is used to then compute your filing fee as it represents towards your stated capital. So I know that's a little complicated, but just bear in mind that each state is different, and They vary greatly as to fees. Other things that will have to be filed in most cases are annual reports. And then once you're in a state, you're susceptible to whatever taxes they have you pay and file. And there may be other filings that come along as well. So back to you there, Bob.
Okay. Hey, Pat, I have a question for you. What normally has to be included in annual reports? Could you give us sort of your practical take on that?
Sure. Good question, Bob. Thank you. As a matter of fact, real briefly, I'll just touch on it's similar to what's in the application for certificate of authority. And that, again, of course, is the name of the company, the state of incorporation, the date you formed your entity and your state of formation, and then in both the application forms for qualification and the annual reports, the names and addresses of the officers and directors. So that's basically what's in the annual report, names and addresses of the officers and directors.
That's great. Does it make a difference if it's a nonprofit or a for-profit, or they're just treated the same?
Well, not every state has requirements for nonprofits to file annual reports. Our own state of New York, they do not have to file a report. Actually, corporations only file once every 2 years a biennial report. But it's usually, again, every state is different.
Yeah, okay. Okay, that's very helpful. Thanks, Pat.
You're welcome, Bob. Thank you.
Mike Whitaker will now briefly discuss how a company may cure a failure to qualify. We've all had clients, we've all had circumstances where we found out after the fact that the client did not qualify, it was supposed to qualify. So what happens after the fact when they have to cure the fact that they have failed to qualify?
Thanks, Bob. You're correct. We all seem to have these clients, whether by accident or on purpose, did not qualify to do business when they are conducting activities within a particular state that would require them to qualify. The state laws, as you can imagine, vary on whether and how a company may cure this type of defect. Generally, the company may file an application for qualification and pay all required fees as well as any penalties associated with its failure to qualify and the late filing. Generally, in such a case, once it's made the filing and paid the fees, the effect of the filing is retroactive. However, in certain situations and in certain states, failure to qualify may prevent a company from maintaining a lawsuit in that state. Therefore, a company should not opt out of qualifying in a state on the assumption that it can always cure the failure to qualify in the future. We're now going to jump back to Pat Nolan at CSC, who's going to discuss some real-life examples that he has seen regarding curing failures to qualify in a particular state. Pat?
Thank you, Mike. Thank you. Well, it runs the gamut of reinstating. Can be as simple as e-filing an annual report in the state of Florida and you're back on your feet, to a more complicated state like the state of New Jersey. In New Jersey, for example, you not only have to e-file whatever annual reports you were delinquent in filing, but then you have to apply for a tax clearance. And believe it or not, it takes almost 3 months to get an auditor assigned by the Division of Taxation to even begin to look at, your tax clearance request. So realistically, it usually takes about 6 to 8 months to reinstate in New Jersey. So that's one of the harsher examples, but for the most part, it can be remedied by filing whatever it was you were delinquent in, sometimes with an application for reinstatement. There are a few states that will not allow you to reinstate, and you have to requalify and start over. The next thing I'd like to discuss, if I might, is just how to terminate your qualification. A voluntary termination, the word for that we use is a withdrawal. And what that involves is similar to qualification. When you went into the state, you file an application for withdrawal to get you out of the state. Some states, again, have a tax clearance procedure, so that can slow the process down. But each state is different, but we're able to help with all of them. Another type of termination of your qualification is one you don't want to run into too often, and that's an involuntary termination where you've been revoked. In most cases, when the Secretary of State revokes your authority, it's because you did not file your annual report or failed to maintain a registered agent. So, again, there's reinstatement processes for that. As far as the regular withdrawal, once you file that withdrawal, the registered agent's authority is revoked in the state. I think there's one state, Maryland, comes to mind, where you have to maintain a registered agent for a year after you withdraw, but on most states, your registered agent is revoked, and that's a good thing, because you don't want to pay us after you're not paying taxes anymore and you're out of the state. But all states will usually ask for an address to which the Secretary of State may forward process, just in case something comes in after you've been withdrawn. They want to know how to reach the company. So back to you guys in Wilmington.
Okay. Hey, Pat, let me ask you a question. On the involuntary termination, the revocation that you talked about,
Right?
Do you get a lot of notice? Does the company whose qualification is being revoked, is that a process that happens real quickly, or is it usually drawn out at least over a month or two, or just, I mean, can you speak to that at all?
Sure, Bob. Good question. I'll use your own state of Delaware as an example, if I might. We'll say now corporations in Delaware, their franchise tax is due on March 1st. We, as a registered agent, and all commercial registered agents, will get a notice from the state, usually around the end of December, and then we forward that on to the person on our records as the recipient. If the report is not filed by March 1st, we send out a delinquency notice. But this is not carved in stone, the same for every state. Some states just feel it's the responsibility of the company to know when their annual reports are due. More states will give you notice and will tell you that you have 2 weeks to file it, or you're going to be revoked, and send a revocation notice after the fact. CSE has tools that, in addition to states that do not give us timely notice, will help a client to, avoid that situation.
Okay, that's great. Thanks, Pat. Very
You're welcome.
good. Let's move to slide 15. Good. Okay, so let's say you've got an obligation to qualify, but you don't do it. Let's talk about the consequences of that. Many states impose penalties or consequences where a foreign company does not qualify to do business. The purposes behind these penalties are typically, one, to encourage foreign companies to qualify. Obviously, that's the most important. And secondly, to provide a mechanism for states to collect some sort of a reasonable, non-punitive fee. Mike Maxwell, I believe you're going to give us an idea of the types of penalties the states sometimes adopt to enforce their qualification laws.
Sure, that's right. I think the main penalty is to prevent foreign companies from maintaining lawsuits in a foreign state's courts. Although some states provide for monetary penalties as well, denial of access to the courts precludes unqualified foreign companies from maintaining lawsuits within their borders until they obtain a certificate of authority, i.e., that is, that they qualify. For example, if an unqualified company files suit, the defendant may move to dismiss on the ground that the company lacks standing to bring that suit. Some states permit a court to stay a proceeding where a foreign company has not qualified rather than dismissing it until such company is qualified. However, in contrast, some states' penalty provisions do not give an unqualified foreign company an opportunity to cure a qualification deficiency after having filed a lawsuit. However, most states expressly do permit unqualified companies to defend themselves when they are brought to court on a basis of fairness. And many state courts interpret these provisions to also allow unqualified foreign companies to file a counterclaim against the opposing party in the same lawsuit. Although I believe there are some states that that's not the case.
Right.
Additionally, I'll note that most states also include a provision that states that a failure to qualify before doing business in a foreign jurisdiction does not impair the validity of its corporate acts. Let's go ahead and turn to slide 16. Great, thanks. So finally, most states include a monetary penalty provision for a company's failure to comply with qualification requirements. Many of these states do not impose a substantial civil penalty for the failure to qualify, but instead require payment of back fees and taxes, plus possibly a penalty for lateness. Other states may impose either a lump sum penalty or include the same provision for payment of all fees and taxes, plus an additional monetary penalty on a pro rata basis, essentially ranging from a $10 per day to a penalty possibly not to exceed $5,000. Pat, it looks like you've dealt with this issue before. Is that correct?
Yes, I have, Mike. Thank you. If you're looking at the screen right now, there's a little chart there. And what that shows is there was a subsidiary of a Fortune 500 company that late last year realized it hadn't qualified in a handful of states where it thought it was. And the fact was that they had been doing business since 2000. The 4 states I've listed on the left, in the middle column you'll see the minimum fee if they were in a position to state on their application for authority that they had not done business. Some states will ask the date you began doing business, and if it's in the rearview mirror, there could be negative consequences. In these states which asked that question, they put down the year 2000, and instead of paying, for example, $600 in the state of Texas, they had to pay $9,815 to the state of Texas because of the penalties and interest that had accrued. Illinois, as I mentioned earlier, is a double whammy because you not only have to pay on your proportion of paid-in capital represented in Illinois with your business and property figures, but also had to pay penalties and interest going back those, 15 years at the time? 15 years. So their penalty, based on their stated capital, had they said they had not begun doing business, would have been $1,814.27. Instead, they had to pay over $21,000. Likewise, Florida, very minimal state usually, $70. They had to pay $19.20. And lastly, Georgia, $225 for the minimum fee. They had to pay $825. So it's a thing you want to, make sure you keep track of and look at your records, because this company was totally caught off guard and, frankly, pretty shocked when, we gave them what these fees would be.
Yeah, I'll say. Yeah, don't mess with Texas. Yeah.
Sounds like there's a lesson to be learned here in taking care of your qualifications before before you get going.
Those are big numbers. Yeah.
Well, thanks, Pat. I guess the last point I want to make with respect to the consequences of failing to qualify is that some states do impose or may impose, in addition to monetary penalties on the company, monetary and or criminal penalties on a company's directors and officers and or its registered agents if they transact business on behalf of an unqualified foreign company. So just keep that in mind as well. Let's go ahead and move on to slide 17 now.
Thanks, Mike. Ladies and gentlemen, we are nearing the end of our journey today. Our final topic is a reminder that other types of laws and regulations need to be considered when a company is looking to do business in a foreign jurisdiction. Mike Whitaker, what are some of these additional laws or regulations that might apply to an out-of-state entity?
Sure, Bob. Thanks. As we kind of suggested earlier in the presentation, there are laws that require companies to obtain particular licenses or permits to conduct particular types of business within a jurisdiction. Qualification to do business in a foreign state does not necessarily mean that a company is free to engage in whatever business it wants, and it needs to determine whether or not any of these particular licenses and permits apply. Certain businesses and industries require these licenses and permits. For example, the practice of law, which we all engage in, the practice of medicine, you have to have licenses for, as well as engaging in activities such as accounting or selling insurance, which we've all mentioned before. Companies may have other regulatory issues to deal with as well. For example, banks have to qualify under Delaware's banking laws before they can conduct any business in Delaware. This qualification process is different than the qualification to do business process. It's much more time-consuming and requires much more disclosure about the company and its business. Finally, many states also require a company to register with the Department of Revenue or equivalent tax agency so that the state is aware of their activities and can collect tax on those activities.
Yes, no surprise there. Thanks, Mike. Ladies and gentlemen, that concludes our prepared remarks. I believe CSC has a few housekeeping matters to talk about and then we are going to entertain some questions.
Thank you, Bob. Thank you, Mike, Pat, all of you. This was a great presentation. We will now open up the Q&A session. Also on the screen, we have a question for you. Would you like a CSC compliance specialist to contact you? Please click one of the options on your screen. And also, just as a reminder, you can download a copy of today's materials from the handouts box. Please note, after the webinar, registered participants will get a follow-up email from LexisNexis. Please follow the link in the email to enter your CLE information. So now let's take some questions from the audience. Marlene is asking, is there any downside to qualifying to do business in any other state apart from the expense in tracking compliance?
Yeah, Mike Whitaker. I'll jump in and try and address this one. It's funny, and I didn't catch who asked the question, but it's actually a perfect question based on the genuine parts case that we talked about earlier today, because the intent of that case, or part of the intent of that case, was to try and address this particular issue. There shouldn't be really much of a downside in qualifying these days. There was always a question prior to that case in Delaware, and again, I should emphasize that case is just a Delaware case, so it only applies in Delaware. But there was always a question of whether or not qualifying to do business subjected you to personal jurisdiction in the case, or in that particular state. But after the genuine parts case, as long as other states tend to follow that, it looks like that question has been answered. And part of the discussion that the court had in that case was that if you didn't qualify to do or to conduct business in the case in that state, the Secretary of State was appointed as your registered agent, and you were subject to specific personal jurisdiction in the state. So it seemed odd to the court that if you didn't qualify, you'd be subject to specific jurisdiction, but if you qualified, you were subjecting yourself to general jurisdiction. So that was part of the court's analysis in determining that qualification should not subject you to general jurisdiction. So with that question, I'm going to say essentially answered, but again, that's only answered in Delaware, but hopefully other states will kind of follow our lead and come out the same way. Mike, did you want to add something?
Yeah, I just wanted to say, also keep in mind, though, as Mike mentioned, it depends on the jurisdiction. In response to the Daimler case, Delaware, had the genuine parts case, but New York, working its way through the New York State Senate right now, is a proposed legislation to essentially overturn the Daimler case and make you subject to general jurisdiction when you register to do business.
Yeah.
And so I think our audience should keep that in mind when they're looking at what states they're going to qualify in.
Well, and I think the point there is, and we said this earlier in the presentation, when you've identified the jurisdictions that you want to do business in, or you want to conduct activities in, not only do you want to focus on the statutory law, you want to focus on the case law, because it's like in the case of Delaware, the genuine parts decision, the Delaware Supreme Court basically said it doesn't subject you to general jurisdiction. So the case law provided the answer there.
Thank you. Alex is asking, Pat, I think this question will be best suited for you. Alex is asking, beyond the filing required for qualification, what other types of filings do I need to consider when doing business beyond my state of formation?
Okay, well, thank you for the question, Alex. Well, we did mention, of course, the filing of the qualification forms and the publication. One thing I did leave out, there are other states that have what they call recording requirements. Kentucky comes to mind, that once the qualification is filed with the Kentucky Secretary of State, you have to record a copy of it in the Recorder of Deeds office where the registered office is located. Other things that I think of are business licenses, which is a huge topic. For example, if you're going to open a restaurant down the street here in New York City in Manhattan, you'd have to get not only filed with the Secretary of State up in Albany, but you have to get permits and tax licenses from New York City. You'd also want to get a liquor license, I'm sure, things of that nature. Other very popular type of business licenses are state contractors licenses, new hire reporting, unemployment compensation insurance, and things of that nature. One thing that's very near and dear to my heart that I can't stress enough is the topic of filing your annual reports timely. One of the most popular services that CSC offers and where our dear customers come to us most often is for good standing certificates for closing. And the one thing that can louse up a closing is when you can't get the good standing only to find out that it's because the annual report wasn't filed. So I can't stress that enough to just keep tabs on the annual reports. Hopefully that was a satisfactory answer. Is there anything else I can help with? Alex?
I think you've taken care of that one. We did get another question from Jack. If a company qualifies when it doesn't need to, could it actually be creating a needless scenario for liability? Would that be a factor to consider when trying to determine whether to qualify?
I'll take the first shot at that. And I think it goes kind of back to the first question. I don't think it's going to be creating any additional liability, and I assume that the premise of the question is I assume that the company is conducting business in the particular jurisdiction, and if that's the case, as we noted a few minutes ago in response to the first question, most states, or at least Delaware, and I'm assuming most states, have a provision that says if you are conducting business and you have not qualified, you are essentially appointing the Secretary of State of that jurisdiction as your registered agent, and they can accept service of process on your behalf, and you would be subject to specific jurisdiction in that case. So even if you haven't qualified and you're conducting business there, you would have kind of the liability issue already. So I don't think qualifying in a state adds to that potential liability. So I don't know that I would consider that a factor. I think I would err, now that we have these decisions from the Supreme Court and even the Delaware Supreme Court, I think I would err on the side of qualifying as opposed to not qualifying.
Yeah. That makes sense. Pat, could I go back to something you were talking about with the business licenses? I think for the benefit of our listeners, some of those licenses are fairly easy to obtain, and obviously service providers like CSC can help folks do that. But there are other business licenses, or maybe not a business license, but like you mentioned, a liquor license. I mean, we've had some experience with that, and that can take a long time to get, right? I mean, there are some licenses that are just not that easy to obtain in a short time period.
Well, Bob, thank you for the question. And to be truthful with you, I don't have a lot of hands-on experience with either liquor licenses or business licenses in general, as we have a whole major division in our Wilmington office in the building where you're located. But if any of our listeners here have any specific questions on business licenses, please send them in, and we will get them answered as quickly as we possibly can. And I apologize that I'm not more of an expert on business licenses, but I felt obligated to bring it up, because I was taking a question about things that might have to be filed after qualification filings.
Sure. Thanks, Pat.
You're welcome, Bob.
Folks, we've had a couple inquiries about how you can obtain the CSC Qualification Handbook. If you visit cscglobal.com/publications, you will find information there on purchasing the handbook. And also, we'll send some information after the webinar, including more details on how to obtain the book. So that is all the time we have today. If we didn't get to your question, we will contact you with a response after the webinar. Thank you to everyone who joined us today. We hope to see you next time.